The views and opinions expressed on America's Workforce Union podcast and its digital media channels are solely those of the speakers and do not necessarily represent the views and opinions of the producers or sponsors.
Welcome to the America's Workforce Radio Podcast, the flagship production of the American Workers Radio and Podcast Network, where organized labor and its never-ending fight to protect the rights of the American worker come first. Now, presented by LIUNA, Laborers International Union of North America. Here's your host, Ed Flash Ferens.
A new report on the state of labor rights around the world, and we find out the U.S. is now on a watch list. Meanwhile, a conservative court rules against Starbucks workers. No surprise there. And today on the show, labor lawyer Andrew Strom will be joining us. Welcome to the Friday, July 10th edition of America's Workforce, where we are available on at least 5 platforms. That includes YouTube, Apple Podcasts, iHeartRadio, Spotify, and Pandora. Andrew Strom will be our featured guest on the show today, longtime supporter of America's Workforce. He's a union lawyer for over 3 decades, educated at Harvard. And every once in a while, he has a post at onlabor.org. This is a service of the Harvard Law School. Andrew currently serves as legal and policy director for the American Guild of Musical Artists, and he does not speak on their behalf. This is something he does independently. And his latest blog is titled, How Judges Chip Away at Statutory Protections for Workers. And he points out it's not easy to write a statute. We're talking about writing a law. There's a lot of process that goes into it, from conservatives, from progressives. They try to make sure that the law is going to hold up in court. Well, right now, the courts are doing everything they go through these laws with a fine-tooth comb, and they pick and choose what they want to eliminate. And in this case, a couple of judges, there was a case where people working at a nursing home were getting screwed on the hours they worked. And the judgment was almost $36 million. And it involved overtime, an overtime gap rule. And Andrew's going to explain that on the show. Well, anyway, to cut to the chase here, the court found a way to eliminate the overtime protections. That's right. They're chipping away. And, a little bit here, a little bit there. Before you know it, you're left with nothing or just crumbs. That's what it's all about. So Andrew Strom will be our featured guest on the show today and talk once again how things are just changing in America on the side of corporations. More for corporations, less for workers. That's exactly what's going on here. Now, a brief look into the world of labor. This segment brought to you by Boyd Watterson Asset Management. We're talking $38 billion of assets under advisement. You can find more at boydwatterson.com. The International Trade Union Confederation, the ITUC, recently released its 2026 Global Rights Index analyzing the current state of labor rights around the world. How about this? For the first time, the index placed the United States on its watch list of nations following a measurable increase in workers' rights violations, putting the country alongside Israel, Niger, and Vietnam as systemic violators. The ITUC, the world's largest trade union confederation, whose members represent over 191 million workers, identified President Trump's attacks on workers as responsible for the placement of being on the watch list. The index describes the stripping of collective bargaining rights from federal workers as, and this is a quote, perhaps the biggest act of union busting in the nation's history, and identifies ICE as creating an increasingly hostile environment for migrant workers. Elsewhere in the Americas, the ITUC added Panama and Argentina to its list of 10 worst countries for workers. Overall, the report warns of an accelerating trend in state hostility toward workers, with attacks on union leadership and increased digital surveillance contributing to the total number of rights violations increasing for the 4th year in a row. The U.S. Court of Appeals for the Fifth Circuit, which is a very conservative court, has overturned a National Labor Relations Board finding that Starbucks unlawfully fired a worker for engaging in union activity. Writing for the court, Judge Jerry Smith ruled that the NLRB relied on faulty evidence in concluding that Starbucks terminated an employee because of anti-union work at one of its Southern California stores. The court also denied enforcement of other NLRB orders, finding that Starbucks has made coercive threats against employees. Now, the case is one of at least 6 NLRB decisions that Starbucks has challenged recently in the conservative-leading Fifth Circuit, despite underlying conduct occurring elsewhere. This is called court shopping. If you have a case, you know where the judges are going to stand, especially when it comes to labor rights. They make sure it shows up in that court. And who loses? Starbucks workers. One more here. Truckers for Werner Enterprises have filed a motion for final approval for a class action settlement, seeking approval from a federal judge in Nebraska for a proposed $18 million settlement. Sounds good, but let me finish the story. The class action represented claims for about 100,000 current and former Werner truckers, covering a period from 2010 to 2023, 13 years. The class action alleged violations in California and Nebraska law, but Werner did not admit to any wrongdoing as part of the settlement. Of the $18 million, $6 million is set aside for attorney's fees for counsel representing the workers, while $20 is allocated to each Nebraska class member, and $40 is allocated to each California class member. Okay? It started out at $18 million. And the workers, respectively, will get $40 and $20. All right, I got to take a break. Andrew Strom, our labor lawyer, coming up next, right here on America's Workforce. Don't go away.
You're listening to America's Workforce with Ed Flash Ferens.
It takes LIUNA to build North America's infrastructure. From roads and bridges to schools and skyscrapers, the men and women of LIUNA, the Laborers International Union of North America, build the projects we depend on. From constructing the Freedom Tower on the site of the former World Trade Center to untangling Washington, D.C.'s congested interstate, LIUNA members do the work that matters. Find out what it takes to be built by LIUNA at liuna.org. That's liuna.org.
America's Workforce is brought to you in part by the Communication Workers of America. You can find more at cwa-union.org.
There is unity and strength for workers.
We are the USW.
We are the USW.
The United Steelworkers.
The largest industrial union in North America.
We represent 850,000 members in the U.S., Canada, and the Caribbean.
We work in metals,
rubber,
chemicals,
paper,
oil refining,
atomic energy,
and the service sector.
We are steelworkers, standing strong and fighting for what's right.
This segment of the show is brought to you by the Brotherhood of Maintenance of Way Employees Division of the International Brotherhood of Teamsters. For more information, please visit bmwe.org.
American workers are sick of struggling to get by. It's time to get ahead. In the Teamsters Union, workers are winning industry-leading contracts, historically high wages, fully paid health care, and retirement benefits you can count on. Across the country, Teamsters fight alongside our brothers and sisters to secure a better life. It's what we've been doing and how we've been living for more than a century. When we fight, we win. Join us. Be a Teamster.
America's Workforce is brought to you in part by the International Federation of Professional and Technical Engineers. You can find more at ifpte.org.
Now, back to America's Workforce. Here's Ed Flash Ferens.
And remember, you can check us out on Facebook or follow us on X, formerly known as Twitter. That would be AWF Union podcast, AWF Union podcast. Let's go to our featured guest today, Andrew Strom, longtime union lawyer. He currently serves as legal and policy director for the American Guild of Musical Artists, who we have featured on the show a number of times. Now, just want to point out, Andrew does not speak on their behalf. What he says on this podcast are his own views. Like I mentioned, Andrew is a longtime union lawyer whose blog posts appear at onlabor.org. Great website. It's a service of the Harvard Law School, where Andrew graduated from some years back. And today we're going to talk about how judges chip away at statutory protections for workers. We've often talked about the weakening of the National Labor Relations Board. Well, there's laws on the books, good laws, bad laws, and the good laws, especially ones that favor workers, sometimes get interpreted not in the favor of workers. Andrew Strom, welcome back to America's Workforce. Thanks for joining us today. Talk to me about your latest blog, because as you point out, when you kick this off, it's not easy to write a statute. It takes, everybody to get together, Republicans, Democrats, independents. There's a lot of hard work. And, you try to do the best you can, especially when it comes to the National Labor Relations Act. But bring in some judges, things can change. Talk to me about what happened here.
Sure. And also, it's very hard to anticipate all the clever ways that employers will try to evade a statute, right? So, I think that's a little bit what this one is about. So there's a case from the Third Circuit Court of Appeals, which covers New Jersey, Pennsylvania, and Delaware. And it's the case is called Secretary, U.S. Department of Labor versus Comprehensive Healthcare Management Services, which is a company that runs nursing homes. And these cases are decided by a 3-judge panel, and there are these 2 judges, Judge Michael Chigaris and Judge David Porter. Chigaris is an appointee of George W. Bush, and Porter is an appointee of Donald Trump. And often on this program, I've talked about, how Trump has appointed all of these terrible anti-worker judges. But I think it's important for people to understand that so did George Bush. And Trump's judges are a little bit worse, but there are plenty of bad judges that George W. Bush appointed as well. And so this is a case where involving the Fair Labor Standards Act. And the Fair Labor Standards Act is another one of the New Deal laws that were passed to protect, workers on the job. And it did 2 things. It set up a minimum wage and maximum hours. And unfortunately, minimum wage hasn't, the law doesn't index it. It doesn't automatically go up with inflation. So Congress has to act from time to time, and Congress hasn't raised the minimum wage since 2009. So the minimum wage has been stuck at $7.25 an hour, which in most of the country makes the minimum wage pretty much irrelevant. And then for maximum hours, this was an era where, workers had been working, 50, 60 hours a week on the job. And it was a real struggle. Unions fought so hard to get the 40-hour work week. And what Congress did was they didn't pass a law that said no one could work more than 40 hours a week. But what they did say is that if you work more than 40 hours a week, you have to be paid 1.5 times your regular rate of pay.
Mm-hmm.
Otherwise known as time and a half. In this case, the Department of Workers were being underpaid. They were being paid they were being basically not paid for all their hours. And the Department of Labor went to trial and got a judgment of $35.8 million against this nursing home operator. And these 2 right-wing judges just set that judgment aside. And the real issue in this case is what's known as overtime gap pay. And what that means is that, so the Fair Labor Standards Act doesn't specifically say that workers have to be paid for every hour that they work. It says you have to be paid time and a half if you work more than 40 hours in a week. But it doesn't specifically say what happens if you're not paid for hours that are, before you get to 40. So, for example, with these workers, um, they may have been paid for 38 hours in a week, but then they did, various off the clock tasks where they actually worked 43 hours in a week, right? And so everyone agreed that they were owed time and a half once they hit the 40 mark. Um, but these two right-wing judges said, oh, but the law doesn't say anything about hours 38 to 40, right? So what that means is that the, take an example of somebody who's paid $20 an hour. Um, and so if you're not paid from hours 38 to 40, that's $40 you didn't get paid, right? But from 40 to 43, you would be owed $30 an hour for each of those 3 hours. So the Department of Labor said each worker would be owed $130. And these judges were like, no, 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 they're only owed $90. But if you do the math, there's 5 hours that they didn't get paid for, and 90 divided by 5 is 18. So basically what these judges are saying is that they can be paid $18 an hour for 5 hours of unpaid time, which sure doesn't sound like time and a half, right? Um, and the Department of Labor has had a regulation on the books since 1968 that addresses this, right? And they say that the extra compensation for overtime work, quote, cannot be said to have been paid to an employee unless all the straight time compensation due him for the non-overtime hours has been paid, right? So this has been on the books since 1968. And think about that. That means it was on the books through the Reagan administration, through the George H.W. Bush administration, through the George W. Bush administration, through the first Trump administration, right? So somehow this bipartisan, officials at the Department of Labor understood that that's the only possible way to make sense of this law, right? Because if you can say to someone, in order to get your overtime pay, you first have to work a certain number of hours off the clock, then that's just another way of avoiding your obligation to pay people time and a half for their overtime pay, right? I mean, the whole point of this law was to spread the work, right? Was to say to employers, you're not supposed to work people more than 40 hours a week. If you have a job that requires more than 40 hours a week, you're supposed to hire another person to do that job, right? You're supposed to create, this was, part of the era when we were still coming out of the Depression and there still wasn't full employment. And the idea was, don't give, 50 hours of work, to the people on your payroll, stop them at 40 hours a week, and then hire somebody else, because we need to get more more people employed. But these guys, these judges, they're just, they have this kind of very wooden application of these laws of like, well, it doesn't specifically say anywhere that you have to be paid for your non-overtime hours. So therefore, the Department of Labor doesn't have the authority to collect for those non-overtime hours, even if the whole point of the law is to make sure that people are paid properly.
Andrew, let me ask you this.
Yeah.
The judgment here, and this came from the U.S. Department of Labor, okay? And they set aside, it was almost $36 million
Yeah.
against the
Real money.
operator. Yeah, real money, real money. Did they set aside all of that money? Did the workers get some chunk of it or a fraction of it? What do
Yeah,
you know
well,
about that?
they're going to send it back to the trial court, I guess, to figure that part out, how much the workers end up getting at the end of the day. I mean, the other thing that's important to understand about this, right, is, I mean, even these two judges recognized that what the company did was wrong,
Yeah.
right? I mean, but what they said is, oh, but the workers, instead of going to the Department of Labor, what they should have done is like gone to the Department of Labor for their overtime claims, but then filed a separate claim, with the state, either with a state agency or in state court, for their non-overtime hours, which, if you think about it, makes no sense, right? I mean, Congress creates the agency to enforce the laws, right? And says to make sure that workers are paid properly. And they're saying to workers, no, you have to go in two separate places just to make sure that you're paid properly. I mean, that really, it's nutty, right? But of course, that's not what they're concerned with, right? They're not concerned with protecting workers' rights.
No.
Right? It's all about, and a lot of this is just in the guy, this is, just another way of making it harder for workers to enforce their rights.
Well, like you said at the beginning of it, I mean, it's not easy to write a statute. When they write the statute, they don't know what's going to happen to it years later. But the judges, depending on who's on the court, they're going to chip away because they're typically on the side of management, not the worker. Andrew, let's take a quick break on this because what you brought up in this conversation, the overtime gap time or overtime gap pay, I think a lot of people listening right now need to be aware of what can happen when you're working overtime. Very important, very important. Andrew Strom is our longtime union lawyer here. This blog is posted on the onlabor.org blog. Got to check that out, how judges chip away at statutory protections for workers. Back in a few minutes, you're listening to America's Workforce.
You're listening to America's Workforce with Ed Flash Ferens.
It takes LIUNA to power North America with affordable energy. The men and women of LIUNA, the Laborers International Union of North America, have the skills needed to build and maintain oil, natural gas, nuclear, solar, and wind projects that are shaping America's energy future. From new energy tech to retrofitted facilities, LIUNA members do it all. Find out what it takes to be powered by LIUNA at liuna.org. That's LIUNA.org.
America's Workforce is brought to you in part by the Iron Workers. You can find more at ironworkers.org. Blue Cross and Blue Shield companies formed out of a need to provide affordable health care to teachers, to loggers, and miners. Back in 1965, the Blues developed the National Labor Office to strengthen its commitment to organized labor. Blue Cross Blue Shield's National Labor Office remains focused on America's workers, advocating for affordable and equitable health care, partnering with strategic alliances to provide industry-leading products and services, and proudly serving more than 18 million unionized workers, retirees, and their families, all working hard for America's working families, for the health of America. You can learn more by following them at Blue Labor on LinkedIn and X, formerly known as Twitter. America's Workforce is brought to you in part by the Heat and Frost Insulators Labor Management Cooperative Trust. Find out more at insulators.org/LMCT. Founded in 1887, the Brotherhood of Maintenance of Way Employees Division of the International Brotherhood of Teamsters represents the employees responsible for tirelessly constructing and maintaining the national rail system in America. For more than a century, the Brotherhood of Maintenance of Way Employees has proven they have what it takes to protect its members and meet the ever-changing challenges of the rail industry. Today, the BMWED continues to fight for job security, fair wages, better benefits, and safer, more modern work environments. For more information, please visit bmwe.org.
America's Workforce is sponsored in part by Boyd Watterson Asset Management, LLC. Find out more about our investment solutions tailored to meet the needs of Taft-Hartley funds at boydwatterson.com.
Now, back to America's Workforce. Here's Ed Flash Ferens.
And don't forget, you can check us out on at least 5 platforms. That includes YouTube, Apple Podcasts, iHeartRadio, Spotify, and Pandora. And when you get an opportunity, here's what you do. Just sign up and receive our shows on a regular basis and give us a rating. Always appreciate those 5-star ratings, so please keep them coming. Our featured guest today is Andrew Strom. Andrew currently serves as a legal and policy director for the American Guild of Musical Artists. He does not speak on their behalf. What he says on this show are his own views, and what we're talking about here is a blog that appears on the website onlabor.org. This is a service of the Harvard Law School. I get a lot of news and information about workers on that website. I suggest you check it out as well. How judges chip away at statutory protections for workers. We're talking about the National Labor Relations Act, which goes back to 1935. Pretty solid law. It provided the minimum wage, which some states are still stuck at, $7.25 an hour. It also talked about overtime. You work over 40 hours a week, you should get compensated for it at time and a half. But there's judges that look at the law a little bit differently, and that's what's contained in the article. What you mentioned here in your article, Andrew, overtime, gap time, I think we need to elaborate on that because the people listening to the show need to know how they can get screwed on wages. I mean, there's a lot of people working overtime. Employers would rather have you work overtime because if they hire somebody else, well, then we got to pay some more benefits. There's a lot of employers, as you know, that will work people up to maybe 38, 39 hours a week so they don't have to pay those benefits. That's going on every day in America. There's also employers that don't want you to be employed. You're a subcontractor. You're an independent contractor. Okay, we've talked about all that on the show. Those that are getting overtime, talk to me about this overtime gap time. I had no idea this was something that we would have a conversation on. What's your advice to workers right now, Andrew?
Yeah, so the overtime gap time issue, it arises because we don't really have the standard of 40-hour work weeks anymore, right? It used to be the case that people, were struggling with too many hours, right? And now, certainly in a lot of parts of the economy, people have struggled to get a fixed work week, right? Like in the retail sector, or fast food. In a lot of places, what they have is everything is by a computer, and they say, the computer tells the business, oh, it's a slack time, so just send people home. Right. So instead of people getting, you're hired and you think you have a 40-hour week job, and then one week you're down to 32 hours, but then
Right.
the next week is a busy time. So then, maybe you're asked to work overtime. And a lot of times people are asked to do things before and after they clock out. Right. So, they're told, oh, this is just setup, but they're supposed to be paid for setup, or this is just cleanup and they're supposed to be paid for cleanup. And so, that's where a lot of these cases come out of is, the sort of, pre-shift and post-shift work that's supposed to be paid for. And so if you're not regularly, scheduled for a 40-hour work week, let's say you're regularly scheduled for, a 35-hour work week, it turns out under this decision that those first 5 extra hours of work, you don't have a remedy under the Fair Labor Standards Act. Now, in many states, but not in every state, in many states, there's a state agency that you can go to, and the state agency will help you collect for those hours because one way or the other, if you work for your employer owes you for that time. So one way or another, you're entitled to collect. The problem is that if your state doesn't have a good agency that's going to help you, then you have to find a lawyer. And if your case isn't big enough, then the lawyer will say, well, it's not really worth my time, right? So that's, I think, the real problem for people is that, what the result of, these judges are like, oh, it's no big deal. You can just, bring your own private, lawsuit in state court to collect this money. But if you're a low income nursing home worker, people don't have their own lawyer. It's like
Yeah.
Donald Trump has a million lawyers, at his disposal. But, regular workers, they don't have a lawyer. So then they have to go find someone and, find a lawyer who knows this field of law, find a lawyer who is willing to take on, a small stakes case. And, and that's a real problem for people. And that's why when Congress passed the Fair Labor Standards Act in 1938, they said, we're going to have a federal agency that you can go to enforce your rights under this law. I mean, that's what's supposed to happen here, right? That's why, you know, there's this whole right-wing attack, and I've talked about this before. We talked about the National Labor Relations Board, to sort of go after these agencies, the sort of backbone of government that is there to protect, regular people, who don't have their own, stable of, you know, private lawyers that they can go to enforce their rights. And that's, and the other thing about this case, that I made the point at the end is that, you know, it's hard to pass a law these days, but it's also hard to repeal a law these days, right? So the business community, like, they can't just go to Congress and say, we want to repeal portions of the Fair Labor Standards Act, right? That's still, these kinds of worker protection laws are really popular, right? And, you know, members of Congress don't want to be on record casting votes against these laws, right? So, but they do this in this kind of stealth way, right? Where instead of going to Congress and saying, repeal these provisions of the Fair Labor Standards Act, they have these court cases where these right-wing judges do it for them.
Yeah.
And, I mean, that's not how our system is supposed to work.
No. They're doing the dirty work. They are, and they're on the side of the employers. Andrew, I can only assume this nursing home was a non-union. I don't think there's too many unionized nursing homes. And if it was a union that was involved in this, it would probably be a different outcome, don't you think?
Well, sure. If people have a union contract, then they're going to be able to go to arbitration. Their union's going to be able to protect them and make sure that they're paid for their hours. Not let it get to the point where $36 million are owed to people. And so that's part of the problem is people don't know their rights, right?
Yep.
So people don't know, like, when they're told, oh, work through your breaks, but we're not going to pay you for that time, right? People are afraid to speak up. I think that's a big part of where the money came from here was people being forced to work through their breaks, or other ways in which people are being, forced to work off the clock. So, right. So people, the way that these kinds of things happen is that people don't know their rights. People know that they can be fired, for any reason or for no reason. Even if maybe they can't officially be fired for, in retaliation for trying to enforce their rights under a law, but they could be fired for any other reason. And it's very hard to decide what the real reason is. People understand that, they could be fired for being 2 minutes late to work, and so, and that's the excuse that the employer gives for firing them, or they could be fired for wearing the wrong color shoes. Really, people can be fired, as long as you're not fired, there's laws on the books to protect you from certain narrow ways of being fired. A clever employer can always come up with a reason to fire a worker. And people know that. And that's why people don't speak up, and that's why people are afraid to enforce their rights. And that's what businesses count on. They count on instilling that fear in people and, trying to get people, not to enforce their rights. And that's why unions are so important, because it's a way that workers can enforce their rights collectively, right? So, you can't fire the whole workforce all at once. And so people can, they're not left on their own to try to be the one to speak up.
Which is why so many employers don't like unions. Well said, my man. Andrew Strom, our designated union lawyer here on America's Workforce. Do check out his blog, onlabor.org, how judges chip away at statutory protections for workers. Good job today. Always a great job, Andrew. You take care. Stay safe. We'll talk to you in about a month, okay?
Sounds good.
And that'll be it for another edition of America's Workforce. Coming up Monday, National Nurses United. Until then, all of you have a safe and wonderful weekend.
That concludes another episode of the America's Workforce Radio Podcast. Thanks for listening, and be sure to subscribe so you never miss a show. America's